Hi everyone, welcome to today's webinar on Divorce and You. This webinar is part of Law Awareness Weeks at CDC 2021, Relationships and Healing. It is a collaboration between Law Society Pro Bono Services, the 5 Community Development Councils, National University of Singapore Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, and the Singapore Corporate Counsel Association Pro Bono Chapter, supported by the People's Association. My name is Liyen and I'm your host. Some housekeeping before we get started. Relevant materials for today's talk can be downloaded via the QR code, which will be provided on the slides during the webinar. A link will also be sent in a follow-up email to you tomorrow. Feel free to ask any question during the webinar. You can use the Q&A icon at the bottom of your screen. Your questions will only be seen by the organizer, and we will do our best to address them during this talk. Please note that this discussion and the materials provided is not intended to constitute professional legal advice. You should consult a lawyer if you require specific legal advice. With that, our speakers for today are Mr. Yap Teong Liang and Ms. Abigail Lee. Our legal expert today is Mr. Yap Teong Liang, founder and director at TL Yap Law Chambers, LLC. Teong Liang is a very experienced and highly accredited family law practitioner. Apart from his family law practice, Teong Liang is currently the chairperson of the Family Law and Children's Right chapter of the Professional Affairs Committee of the Singapore Academy of Law, and chairperson of the Family Law and Family Rights section of Law Asia. He also sits on the panel of child representatives at the Family Justice Courts. Joining Teong Liang on the panel today is Ms. Abigail Lee, founder and executive director of Healing Heart Center. Abigail has over 15 years of experience as a professional counselor with a focus on children and adolescents. She is appointed by the Family Justice Courts as a parenting coordinator and by the Singapore Mediation Center as a collaborative family practice counselor to work with families undergoing separation and divorce. A full bio of our experts are available for download. Teong Liang and Abigail, thank you for joining us today.
Thanks for having us.
Thank you very much.
All right. For everyone's benefit, this is what I hope to cover today. We will discuss your emotional state during the divorce journey. We intend to talk about your eligibility to apply for divorce in Singapore. And then we will touch on the ground of divorce, court procedure, and some new developments in the family justice courts. And finally, we'll be talking about ancillary matters. So it's quite a lot of material. I might go a bit quicker on some slides, especially in those areas where we have provided excellent materials for you to download and to review in your own time. So let's dive right in. Generally speaking, I think there are 2 major scenarios when someone decides they want a divorce. Either you discover a shocking fact, makes you decide it's impossible to stay married to your spouse, or you have been in an unhappy marriage for a long time and you finally decided you cannot continue in this marriage. So what is clear in both of these scenarios is that it is emotionally trying and very difficult for all parties concerned. So before we talk about the law, I'd like to first deal with this issue. For someone contemplating divorce, when is a good time to seek counseling and what does counseling do for them? Abigail, would you like to get us started?
Yeah, I think when we talk about counseling, I guess for the purpose of this webinar, let's just kind of have like a little definition so that we are all kind of like on the same page of what it does. Counseling really is the process of listening to someone seeking help. So during the counseling process, it really helps to increase the self-awareness regarding the impact of some of the decisions or some of the thoughts and feelings that someone is actually currently having, and in this context pertaining to divorce, as well as understanding the strengths that the individual might have with regards to problem solving, so that you can look at developing skills for coping and resolution skills during this process. So in terms of when it's a good time, it's anywhere along the process, even before you start any divorce proceedings. If you're just contemplating, like Liyen, you mentioned just now, they might have been in an unhappy marriage for quite a while, and they might be contemplating divorce. That's a good time. Even if you are in the divorce processes and there are a lot of stresses that comes out from divorce proceeding, that's also a suitable time. So there's no like fixed good or late or bad time. At any point in time during this process, counseling is suitable.
Teong Liang, I'm interested to know, I know that you've dealt with and helped many clients. And so amongst these clients you represented in a divorce case, do you notice a difference between clients who might have, whether it's court ordered or on their own volition, gone for counseling, and clients who have sort of dead refused and just went ahead with the divorce process without any counseling?
Certainly, Liyen. I think that, divorce is always a difficult journey. It's a very emotionally charged area. It involves the breakdown of a marital relationship. Sometimes it involves a dispute, right, between parent and child. So they're very difficult issues. On top of that, as we started off the emotional journey, right, as you mentioned earlier, that's over and above the legal issues they would have to navigate. So if parties have gone through some form of counseling, I think my experience is they're better off in terms of where they are emotionally. They are able to process, right, the more difficult aspects in the divorce better, as opposed to, you're having the adrenaline pumping, right? And you're making decisions which may not be rational, which may not be in the best interest of the children, which may not be forward-looking. So yes, there is a difference I see for parties who have gone through counseling. And in my practice, I do recommend that, having spoken to the clients, if I feel that counseling is something that will assist them, I would suggest that they go for counseling.
Yeah, I think I cannot agree more. I mean, I think from, in some ways, personal experience, I think sometimes when although I myself have not been through a divorce, but well, actually, as a child, I have. And I think what tends to get neglected is that, we are very concerned with the law, with our rights, and the issues that come up, the legal issues that come up in the divorce process. We often neglect, especially when families are involved, when there are children. Our own emotional state does affect all parties at home. So personally, I would definitely encourage anyone considering this process to perhaps consider going for a counseling session first. Yeah, and to drop preconceived notions as to what that might entail, because I have discovered it's quite different from what you imagine it to be. Yes. Okay, but moving on, let's now deal with the legal aspects. Singapore has seen a steady rise in international marriages and divorces over the years. I think right now it's about 1 in 4 international marriages, or transnational marriages, they call it. So meaning one spouse is neither a Singaporean citizen nor a PR. And so I feel it will be useful to start by setting out the criteria which must be satisfied before the Singapore Family Justice Courts can hear a divorce case. So Teong Liang, what are the criteria that must be met before someone can file for a divorce application in the family court?
Sure. I think there's 2 criteria, essentially. One is if parties or either of the parties are domiciled in Singapore, so you are basically a Singapore citizen, that will qualify for the Family Justice Courts to have jurisdiction over the divorce. However, if neither party is a Singapore citizen and they're not domiciled in Singapore, then the criteria would require one of the parties to the marriage to be habitually resident in Singapore for a minimum period of at least 3 years prior to the commencement of the divorce. So for example, if you have, as you mentioned, a transnational marriage, right, in which you have an expatriate coming in or a non-Singaporean coming for work, or two non-Singaporeans coming in for work, and if they've been working here, living in Singapore for more than 3 years, and unfortunately there are problems in the marriage and they're contemplating divorce proceedings in Singapore, the Singapore courts will have jurisdiction if they've been habitually resident for more than 3 years.
Okay. And I think there is an exception when it comes to this. There is also a time bar issue when it comes to marriage, meaning that if you're married for less than 3 years, you can, but you need to prove exceptional hardship.
That's correct. That's sort of a policy consideration, right, for the institution of marriage, so that if you get married within the first 3 years, you can't just automatically file for divorce, right? As of right, you would need the permission of the court to do so. Okay. And that would entail an application to the court, and you would have to show either exceptional hardship or exceptional depravity. Not easy to obtain such permission, because if the court easily grants such permission, then everyone would just want to apply, right, to file the divorce within the first 3 years. So it actually gives the parties an opportunity to try and work through the challenges in their marriage, either through counseling, marriage counseling, things like that, as opposed to having the idea of divorce being the first port of call, right, if there's a problem in the marriage. Right. And I think that's important to maintain, right, that 3-year time bar, as we call it.
Right. Okay, so with that in mind, now that we've settled whether you qualify for a divorce in Singapore, let's look at the ground of divorce. Now, the Women's Charter, which sets out the law in Singapore concerning civil marriages, provides just one ground of divorce, but it lists 5 factors which will satisfy this ground for divorce, which means to obtain a divorce in Singapore, the applicant needs to satisfy at least one of these 5 factors. Would that be right, Teong Liang?
That's correct. Just a clarification, just one would be sufficient, not at least. So any one of the 5. So these 5 factors, as we call it, right, will be adultery, unreasonable behavior, desertion, or separation. And separation takes 2 forms. One, separation for a period of 3 years, but you require the consent of your spouse, or without the consent, then it's a separation period of 4 years prior to the commencement of the divorce proceedings. If you see from there, the factors of adultery and unreasonable behavior and desertion are more fault-based, whereas in the separation of 3 years or 4 years, it's less acrimonious. There's no fault apportioned, right, or attributed to any of the spouses in that sense. I think the majority of cases in Singapore, there are quite a number of cases in which parties do divorce, but they rely on separation, right, as a reason for the divorce. And that takes away any of the sting, right, as to who's to blame for the marriage breakdown.
Yeah. But in that context, I mean, I believe I speak for many when we say that we still have the impression that whether or not your ground for divorce or your factor to prove the ground for divorce is fault-based affects what happens later in ancillary matters. It may affect your division of matrimonial assets, or maintenance, or custody especially. So what is your view about that? Does it matter which factor we use when we make an application for divorce in Singapore?
The reason or the factors we rely on for divorce is really confined to the reason for the divorce. So for example, if a spouse has committed adultery and you rely on that as the reason for the divorce, it does not mean that it will entitle the spouse, right, to gain more share in the division of assets, or to disentitle a spouse from obtaining a maintenance or a share in the assets. So in that sense, when we talk about the whether it impacts later on, and that is when we'll probably come to the discussion later on the ancillary matters, on children's issues and financial issues, it will have no impact. But having said that, it depends really, for example, if you rely on unreasonable behavior, right? And if the particulars of unreasonable behavior alleges, right, then the other parent is a bad dad or a bad mom, then to that extent, yes, it can have an impact on the questions of custody, care, and control of, for that matter, access.
Okay.
So when we look at the larger picture of things, most of the divorces in Singapore are actually uncontested in respect of the reason for the divorce. The reality is there is probably no point, right, having a contested divorce based on the reason for the divorce, because the court is only focused then in that kind of scenario as to who's to blame.
Mm-hmm.
And because it does not have an impact on the ancillary matters, it doesn't really matter who then quote unquote wins or loses that part of that case, right? And as we all know, having a contested divorce, having a trial does several things. One, it increases the acrimony potentially between the spouses.
Yes.
And that may have a knock-on effect, right, on trying to resolve the ancillary matters later on. Two, it obviously has an impact on the cost, right, the time, right, taken to resolve this aspect. So most of the cases are uncontested divorces in Singapore, and rightly so. And the focus should be about resolving matters regarding the children and the financials, as opposed to who's to blame for the breakdown of the marriage.
Yeah. Abigail, on that topic, right? In the course of counseling couples going through divorce, when it gets prolonged, what then typically happens, emotionally for them, when due to inability to agree, the process just gets prolonged because parties are just not able to come to agreement, especially when it comes to either a ground for divorce, ancillary matters. Do you notice a difference?
Yeah, and I think many times clients or individuals that I've worked with, so much of the focus is on them individually. And I think like Teong Liang mentioned, even before or during the divorce proceeding, there's already a lot of emotions that's very charged up, the adrenaline. And at the same time, there's also a lot of what I call mixed bag of emotions to kind of have to work through depending on the reasons leading up to the divorce. A lot of confusion, and then it swings from confusion to frustration or to anger, to disappointment, to betrayal, to longing about getting back, So all these bag of emotions are already present within an individual to have to work through and to process through, what's more over an extended period of time. And I think what many individuals and also tend to neglect how it then spills over to impacting those round about them, particularly to the children. So not just you are experiencing prolonged effects and having to deal with the emotional aspects of things that come up, the emotional and mental state of your children, loved ones around you, sometimes even friends, because during the process, a lot of individuals also tend to go to their friends and then have a ranting session and share a lot. So even friends can experience that spillover fatigue, I kind of call it, of that mixed bag of emotions. So I do see a difference between the differences where it's the proceedings and all that, the process is more prolonged.
Yeah, definitely. So keeping that in mind, let's now move on to divorce proceedings. Okay, this part I'm going to go through a little bit quicker because the Family Justice Courts has an excellent set of updated material. There's a leaflet and a booklet which shows you the divorce process, and it uses infographics. It's very clear, so please download those resources. You see the QR code on your top left-hand corner. So if I may quickly summarize the process, stage 1 is called dissolution of marriage. It starts from when you file the writ of divorce until the grant of an interim judgment by the court. And then stage 2 is what we call the Ancillary Matters stage, which will cover your division of matrimonial assets, maintenance, custody and access issues. And both these stages can be uncontested or contested. So Teong Liang, you know, the simplified divorce proceeding that we were talking about would require for both stage 1 and 2 to be uncontested?
That's correct, Liyen. And what this simplified track has come about from the changes to the Family Justice Act, right, in 2014. And the idea behind this is to encourage parties to try and reach a resolution on both what you call stage 1 and stage 2, prior to even starting or commencing divorce proceedings. And that can be done in many, many different ways. And I think the statistics from the family justice courts are very, very encouraging. It's about 60% as of last year, in which the cases which have been filed in court are found on a simplified track. So you can 60%. Tell that's correct. So if you see that, you know, it is already more than half, right, of the cases that comes before the courts, in which everything is settled before it's filed in court. You know, so the process of getting to that settlement, they're quite varied, which I think we'll also cover in a while, right? The various options that are open, right, to parties and to parents to resolve these things. But it is an important aspect, and it's very encouraging, and it's something that assists parents, the families, right, to move forward, right, rather than get bogged down into a long litigation. So yes, the simplified track is one of them. That's for having both the divorce reasons and the ancillary matters resolved. Sometimes you can still settle and have it uncontested even before you file the proceedings, the reason for the divorce. That means parties are trying to resolve matters by negotiations, mediations, for example, and maybe they don't have a full settlement, or what you may have heard, what we call the global settlement on everything, right? But you have a partial resolution. So the partial resolution could be a settlement on the reason for the divorce, or it could even extend to some parts of the ancillary matters that have been resolved. So they could resolve the children's issues, for example, but the financial issues they can't resolve. Or they resolve the financial issues, but can't resolve the children's issues. Right? So that's also a possibility that when you file the proceedings, you can have a partial agreement. And then what then happens is you then try and resolve and either by way of a court decision, or we still go through, right, the process of trying to mediate, right, and settle these other aspects, which they tried to do so before, but unfortunately couldn't. You know, but there are many, many opportunities in the course of divorce proceedings, right, to facilitate and assist parties to have that opportunity to settle these kind of things.
Right, and later on we will learn about how the court, even during a hearing, can at any point in time order parties to go for mediation as well.
That's correct.
Right. Okay. So for now, I'm curious about this thing that I have heard. I understand that if there are children below 21 years of age, then the applicant has to go for a counseling session called the mandatory parenting program, even before you commence divorce proceedings. So can you tell us what this mandatory parenting program entails, Abigail?
Yeah, Liyen, this is a 2-hour program by the Ministry of Social and Family Development. So you can find out more information about it on the website as well. Just with the recent COVID situation, you can actually apply and go through it online. You do not have to attend this session with your spouse. And it's a 2-hour session. And basically what it covers is it looks into issues like financial challenges of divorce, impact that divorce might have on living arrangements, child custody and access, as well as the importance of co-parenting and actually having a parenting plan in place. So these are some factors sometimes that individuals may not have considered, and they might not have thought through even before going when they're thinking through about divorce. So hopefully with this program, what it hopes to do is it extends the individual's knowledge and understanding that more than just going through the proceedings, there are a lot more other factors that you actually have to take into consideration and to think through the implications of the actions and the decision that you're about to make, and really kind of, I think, asking yourself, is divorce really what I want?
Right. And this mandatory parenting program doesn't include the child.
No, it's not.
Right? This is not the counseling session for
No.
the child. That would be a separate matter.
Yes, that's right.
Okay. Okay. So let's then talk about mediation and other resolution methods in the next slide. So we know that, as I was just saying earlier, the court can order parties to go for mediation and counseling anytime during the hearing. So it's very common, one very common question. In fact, at this point, as I'm talking, one participant has asked the question, which is the thing that I'm about to raise. Can I compel my spouse to go for counseling before divorce proceedings are started? So this is quite slightly different to the question I was about to ask, which maybe you can deal with it at the same time, is about a spouse who is reluctant or very resistant to going for counseling. And often people wonder, what is the point of me going by myself? Because my problematic spouse refuses to go, right? Obviously, I'm starting divorce proceedings because there's something wrong with my spouse, and he's the one or she is the one who refuses to go. So I guess there are two things here. One, what happens when one spouse is very resistant? And then the other one, which is a participant's question, can I compel my spouse to go for counseling before divorce proceedings begin?
Yeah, I think we are looking at counseling from two perspectives. There is what I call voluntary counseling, where you go and speak with the counselor, and there are also court-appointed counseling, where some of these takes place during the divorce proceeding. So when it comes to voluntary counseling, well, in a way, you can't really force someone to kind of attend counseling. And what I usually suggest is for you as the individual to take that first step, to attend counseling, and to also process and think through what has taken place, what has been going on within the marriage, what has been your input, and maybe even in terms of how do you help, how might you better manage and cope with some of the challenges and issues that have come up in the marriage, and also to deal with maybe some of the stresses that have arose in the marriage. And as I'm just sharing this, I'm just thinking of a few couples that I work with where it's why do I need to come? If my spouse come along, then everything will be fine. He or she is the one who needs counseling, not me. And if he or she goes and get their act together, it will all be good. And I put out an encouragement to the individual and say, how about you just come and take a look at what's happening with you, because there are also definitely negative emotions that are coming up and surfacing for you. And let's talk about that and work through that and see if, as in the process of working through that, changes can then take place in what you are inputting into the marriage. And I have seen individuals who have decided to do that. And as a result of counseling themselves, going through the process individually, their spouse starts to see the change in them. And it opens up the other reluctant or resistant spouse to then say, well, maybe I would come along to have a session and check it out. And as a result of that, the nice things for me as a counselor is to then see reconciliation and restoration take place for these couples, to be willing to work through, not necessarily easy, but to work through differences, and also to remember why they got married in the first place. I think many times when they are going through divorce proceeding, many people forget that, hey, I got married to this person for a reason.
Yeah, I like that. Teong Liang, what is the difference between mediation and counseling?
Mediation is a process whereby you have a mediator who's not a judge, who's not someone who adjudicates, but it's a neutral person, doesn't represent either party, to try and facilitate an agreement, right, or a settlement between the parties. What the mediator does, right, is really do what we call in mediation parlance, right, option development. So we try and be creative about solutions, options. And I think the important process about mediation is this, that it seeks to try and move the parties away from positions. You know, in a legal sense, right? When you're in court, you're always saying, I want this, I want that, I don't want the other party to have this. So you're talking about positioning, right? And legal positions. Whereas in the mediation, we move away, right? Almost completely in an ideal situation from positions. We try and find out what's the underlying rationale or reason why there's this proposal that has come about, right? It could be for variety of reasons, because the spouse has been hurt very badly and deeply, right? And wounds cut deep. There may have been previous and historical, right, elements involved in that, and hence it directs a party to take a certain proposal, right, in the ancillary matters, for example. So mediation tries to unpack that, and then rebuild. Sometimes the experience I have in mediations, and I sit as a mediator, it can be very fundamental, but people don't see it. And it could be as fundamental or as basic as they want acknowledgement, because during the course of the marriage, maybe for whatever reason, right, it's taken a certain trajectory. A spouse may feel unappreciated, etc., feel taken advantage of. But really, at the end of the day, right, they want acknowledgement, or they want acceptance, right, even within ourselves, right? And maybe that's one way that I can segue into answering the second part of the question: what's the difference between mediation and counseling, right? And so counseling, I think, helps you to do that. It helps you to process internally. And I think that, from experience, a lot of the issues in a marriage really, I think, start off with communication, or the lack of it, or a wrong approach to communication. So even in family lawyers, when we do our own training, right, we learn to communicate, we learn to reframe things. We don't put it out there as totally just black and white, because the tone, the receiver, the message, right, can become agitated. But you can make the same point in a very nice, gentle way, and still make the point. So sometimes the counseling may help parties to look at it from that angle, and that's, I think, what Abigail was referring to, right? When you say that there's a change in the parties, right, when they get to counseling. So counseling actually brings, in my view, a huge sense of awareness, right, as to maybe what we've been doing doesn't sit well with the spouse. It may do for a while, until the tolerance level reaches its limit, and then it overflows, right? It always becomes something along those lines, right? That everything is fine for a while. And even if you're not talking about marriages, you're talking about boyfriend-girlfriend relationships, right? It's probably similar, right? And it's also similar, if you think about it at a deeper level, between parent and child. How we do that, how we communicate, it then helps deal with the bonding of the child, the interaction with your own children. And I think counseling does many different things, right? And helps parties in many, many different ways. And I think the starting point is self-awareness. Hence the earlier point which Abigail made, right? Sometimes parties don't think I need to have counseling. It's my spouse that needs the counseling. Everybody else needs counseling except me.
Yeah.
To me, that in itself, that approach is a red flag already. All the more the person who suggests that is the one that probably needs counseling. So that's the difference in really brief terms.
Yeah. Okay. That was helpful. And are there other methods? Because here we've talked about counseling. We've also said that the court can order both counseling and mediation. Are there any other methods of resolution for parties who are in the midst of or intend to commence divorce proceedings to avoid having to do the uncontested route?
Indeed, there are. I think it is very basic level negotiations, discussions between the parties amongst themselves. It always generally starts off with that. And I have clients who ask me, look, if there are problems in the marriage, should I stop talking to my spouse, right? And just start writing lawyers' letters. And the view I've always taken is the answer is no. We shouldn't be writing lawyers' letters, right? It incurs additional costs. It creates positional, right? Lawyers' advice and all that. And particularly when you have children, I said that even when your proceedings end, right, you'll still have to talk to each other because you have children. You know, and you'll still continue talking to each other even if your children are above 21 years of age, right? So if you stop talking, the communication stops and the chances of reaching a resolution become increasingly difficult. So it is about doing that. It's about continuing the communication. Lawyers will help in the negotiations, taking the clients through, right? Understanding their own case, the pros and the cons. Then other option of a dispute resolution, which we mentioned, mediation. Another one is what we call collaborative family practice. That's a slightly different process than mediation, and it is not for everyone, right? It is dependent on the nature of the case and the parties involved. As a starting point, parties do not want to go to court. As a starting point, they do not want a judge to decide the outcome of their case. So both parents want a settlement on their terms. On their terms, meaning I don't want a third party to decide it. On my terms, meaning we want as a couple, as a parent, to decide these things. Right? So collaborative family practice assists parties in doing that. You have lawyers who are collaboratively trained to do that. It's an open meeting in the sense that we call it a four-way meeting. Sometimes it can extend to five-way or six-ways because child mental health professionals can come into the collaborative practice arena to assist parties, or financial consultants, right, can also come in. So the whole idea there, including the lawyers, it's non-adversarial. It is about finding options for parties to resolve their case outside of the court. But like I said, it doesn't apply to everyone.
Right, okay. But these would be the few resolution methods that parties can consider.
That's correct.
Okay, so before we move on to ancillary matters, which would be our next slide, I'd like to deal with some of the questions that participants have raised. Some of them are completely unrelated to what we've discussed, but nevertheless, I think it's fair to deal with them. So one participant has asked, I have heard of prenuptial agreements. Are these valid in Singapore? And if so, if the terms are not fair, does the court have the power to ignore the prenuptial agreement?
Yes, it's a good question, because prenuptial agreements probably many years ago didn't feature as much. But the short answer to the question is prenuptial agreements are considered by the courts. It does not bind the judge, obviously, in the ancillary matters. I can think of the rationale for that, to put it simply, right? You can have a prenuptial agreement and then you divorce 15, 20 years down the road, right? It doesn't mean that the prenuptial agreement and the terms there obviously were made at circumstances that are very different, right? Having had a long marriage or medium marriage with 2 or 3 kids, as an example. So what may have been agreed at the time of the prenuptial may not be relevant when we apply the law of divorce, right, at the time of the divorce. So the law is the courts will take into account and does consider the existence of the prenuptial agreement to determine what was the intention of the parties at the time of the prenuptial. But not bound by it. The court can totally depart from the terms because circumstances are very different and the terms at that time may not have been fair. To give a bad example, just to by way of analogy, you can say if we divorce, right, the wife shall receive no maintenance, assuming.
Okay.
Then you have a 10-year marriage. The wife has given up the career, right, from the time of the marriage or when the time the children come around, been out of the workforce. When you divorce about 12 years down the road, right, you just can't say no maintenance, because absent the prenuptial agreement, the wife may be in a position to claim maintenance and claim reasonable maintenance. So that's just an analogy I can share, right, to try and help everyone understand where the prenuptial fits. But the intention is there, it doesn't bind the court, but they do take it into account as an agreement, just as much as a deed of separation. So deed of separation, you could have parties having problems with the marriage, and then they enter into a deed of separation, they get into a period of separation. Whatever is agreed in there doesn't bind the court also ultimately in the divorce, but the court will take it into account, again, to demonstrate what the intention of parties is. So the prenuptial is obviously before marriage. In the words of the Women's Charter, it's an agreement made in contemplation of divorce. So technically the prenuptial is that, and a deed of separation is that also.
Right. So, but when you're talking about the court considering the terms in the deed of separation, what actually I didn't know was that in a deed of separation, you can actually set out certain terms relating to, say, custody, access, and stuff like that. That's what you mean, right? Not so much, say, parties agree on the date they have separated. That I assume will be accepted by the court.
That's correct. I mean, I have a view on this, that there's no point having a deed of separation, right? And having it drafted out just to state what day and date and year you're separated. You don't need that. The court doesn't need that agreement for just that purpose. So if you're going to enter into a deed of separation, if they're going to get into a separation because no divorce yet, they're still thinking about it, but they need to have in place arrangements for the kids, for example, interim arrangements for finances in place. So those things you should put in a deed of separation. It sort of allays concerns of either of the parties, right? They know, okay, during a period of separation, these are the parameters of the living arrangements. Yeah, so okay, that would be helpful in a deed of separation.
Right. Okay. So this is an interesting question for you, Abigail. This participant says, I am fearful of my spouse who has been physically abusive against me. So if we choose to go for counseling, must I be in the same room, or can the counselor help be a go-between so that I don't have to see my spouse face to face? Yeah. So I think this is a question about, what the counseling process is like.
Yes. And I think where there are abuse situation, be it with the kids or with the spouse, I think we do need to look at possible family violence issues and child abuse issues of that sort. And I mean, I don't know fully the nature of the situation, but possibilities in terms of looking at protection orders and of that sort. When it comes to counseling, when there is a genuine, when this has been flagged up by the client, what I usually tend to do is, again, depending on if they are in the same room or if it's a joint session or not, there are many different possibilities. There can be joint sessions, there can be individual sessions as well, where when it comes to individual sessions, basically the other spouse do not have to see each other. If not, if they're in a joint session, then there can be arrangements where one spouse leaves first, and then we can look at having the other spouse leave at a later time, so that there can be some protection that way as well. And in counseling, we also talk a lot where there are concerns and red flags like this. We talk a lot about safety plan, what are some of the things that you can do to protect yourself, what are some of the numbers that you can call in times of emergencies, and all that sort of thing. Yeah.
Okay. Practical question. What are the costs involved when people, I think and I'm speaking for quite a number of participants, there seem to be quite a lot of questions about counseling. People are interested in whether, what circumstances under which the court would mandate counseling. So, and then, how does one start counseling? Where do you go? Because I mean, I suppose one way is if you go to court and you wait, right? You start your divorce application, you wait for the court to order it. But for those who are interested in doing it before, how do they start? Where do they go? What might the ballpark costs be?
Yeah, I'll talk about that first, and then Teong Liang can kind of hop in with the court-mandated one. Again, it's a continuum. There are social service agencies that actually provide marriage counselings, and those sessions can be subsidized depending on your income level. So for those, what you can do is every community would have a family service center, and you can actually go to the MSF website. There is a family service center locator. You key in your postal code, and the nearest family service center that it's near your residence would come up. So you can make inquiries there. And then, of course, on the other continuum, there are the private counseling centers and private counseling agencies where fees will be a lot higher in that regard. Yeah.
Okay. So, Teong Liang, under what circumstances would the court mandate counseling? I think, yeah, interesting.
Mandated counseling is provided for in the Women's Charter. So when you start divorce proceedings, and if there are children under 21, parties will be directed and mandated to attend what is called the Child Focused Resolution Center. It's basically a family dispute resolution mechanism, right, for parties to attend, right? So it's sort of sets race also, right, to mediation. At the very first session, what will happen is you'll have a mediator within the family court system itself, a judge mediator. And sitting with that judge mediator is actually a family counselor, right, who works within the family justice courts, or the FJC for short, right? They call it the CAPS, right? The Counseling and Psychological Services Department or arm of the family justice court. So these are all professional counselors. They do a very good job. They speak to the parties, and the focus at that point in time is really the focus to help parents navigate a resolution to the children's issues. You know, but when I say navigate, obviously they have the background, they have their understanding of where the challenges are, you know, and then they try and facilitate both parents trying to reach a resolution. Right? So that's in the first session. And then they'll come back for another session. Sometimes the second session, not sometimes, but the second session is really a mediation session where the parties and their respective lawyers will attend. And if they're not legally represented, that's also fine. They will attend the mediation session on their own if they're self-represented.
Right.
And in between the two sessions, if the family court counselor feels that there is a need for another session before the actual mediation session, then they'll fix that session together with the parties. But in that discussion with the family court counselor, the lawyers are not involved in that process, right? But if there's a settlement reached, the parties are given the opportunity to look at those terms and go back to their lawyers to look at those terms. So the lawyers obviously to draft out the necessary court for this.
But this is at the Child Focused Resolution Center, right? So this session will deal with matters outside of custody and access?
It will. They deal with the custody, care and control access first. And then when I talked about the mediation session, they'll move into trying to resolve it, and then they discuss the financials also.
I see.
Yeah.
Okay. I think for everyone's benefit, I believe many participants are always very interested and have a lot of questions about ancillary matters. So don't worry, there will be a Q&A session at the end of the talk. So if you have questions, please go ahead to ask them, and we will continue to try to deal with them throughout. But now let's talk about ancillary matters. It's the last segment of the talk. We will be talking about care and custody of children. We will talk about your access issues, custody issues, and then we'll talk about maintenance for spouse or children or both, as well as discuss the distribution or division of matrimonial assets. And there is where you can ask your questions about CPF distribution or HDB related questions. So don't forget to use the question function on your webinar screen to ask your questions. Okay, perhaps let's begin by talking about the children. I think the children are probably the most tricky bit when it comes to ancillary matters, both for the child, the parents basically. So perhaps Teong Liang, you can run us through the court's approach when it comes to deciding matters relating to the children. I know that there are three aspects. And they're kind of separated, although related. There's custody. What does that mean? and then there's care and control, and then there is access. I don't know, is that right?
Sure. But before I get there, that's absolutely right. And the terminologies are fairly important because it's quite easy to get confused between the two of them, particularly custody and care and control. But before I get there, the answer to your earlier question, what's the court's approach, right? Well, it is the law, which is inscribed also in the Act, right? That when a court looks at trying to decide issues regarding the children, the welfare and the interests of children are paramount. Okay, so it may be a situation, and more often than not, the father may think this is best, the mother may think something else is best. Sometimes it boils down to different parenting styles. It could be a whole multitude of reasons for that, but it doesn't mean that the court is going to go with either what dad or mom says, right? Sometimes they have the ability to appoint and call for welfare reports, for example, or custody evaluation reports or access evaluation reports. So the whole idea of that, right, and the focus of that is really to try and find the best arrangements moving forward for the children. It is quite commonplace that, when we get into a dispute on this, they always go back, right, into the history and the past, right? And we see lots of pages and pages of affidavits, right? Sometimes it's tantamount to character assassination, right, of the other spouse, which is actually not helpful. That doesn't set the platform for what are the future arrangements, because assuming the kids are 12 or 15 years old and teenagers, for example, what happened when they were 2 or 3 years old probably doesn't matter too much, right? Which will assist a court making decisions for a teenager. Right? If I come to the terminology of custody essentially means making major decisions involving the children. Primarily, it will involve education, health, and religion. That's major decisions. And the approach of the courts on custody from about 2005, right, is to incline towards joint custody. And rightly so, because the idea is to encourage parents to co-parent their children post the breakdown of the marital relationships. Why? Because the children will benefit, right, from the joint decision-making and discussions of their parents, as opposed to a parent having the sole decision ability to decide everything on education, which school, etc. Because in a normal marriage, in a happy marriage, that's probably what will happen, right? Parents discuss which primary school to go to, should we now move house, right? And so that we are within 1 kilometer, things like that, right? These are all discussions I think we normally have, right? In the Singapore context, right? I think when on education, if you think about it, when they get into which secondary school, like that, it's not so much the parents' choice. It's really fortunate, unfortunate results based. Right? I know it's down PSLE year, right? Timing right now, but it's more result based, and similarly for junior college. So that probably takes a lesser importance as the children grow up. Care and control is the day-to-day care arrangements for the children. And normally care and control is either with mom or with dad. Right? In some cases where both parents have a very high ability to cooperate, communicate well, logistics-wise, any other aspects on the children's living arrangements, there can be shared care and control, as we call it. Right? And that normally happens for younger children. Obviously, the challenges of a shared care and control arrangement become more pronounced, right? Once they're in formal schooling. Right? So sometimes in formal schooling, that arrangement may not work so well because you're looking at school books, you're looking at homework, you're looking at who's going to prepare for the test. So unless there's a very high degree of cooperation, right, and commitment by both parents without disagreement, generally shared care and control will not be granted if there's acrimony, etc. Access is where it's allows contact time between what we'll call the non-custodial parents. So if, let's say, mom has care and control, that will more likely than not have access to the children. And access can take many different forms. In the norm, it will be the weekend access, can be overnight access, it can be sharing of the school holiday access, public holiday access being alternated January or Chinese New Year, Eve the first day the second day. There's no fixed law on that. It's really, that's where we go back to mediation, we go back to discussions, what's the best arrangements, and we take it forward from there. That's the access component.
On the access component, I mean, for some reason, it just seems to be such a struggle for parents who have gone down this path of divorce, because very often there is so much unhappiness that I have personally, whether it's friends or relatives, heard many stories about one spouse not granting access or just making access difficult for the other spouse. So in reality, when the court makes an order, what I'm curious to find out is how is that executed? I mean, what happens when, say, the court orders that a child stays overnight with father every Saturday, for example, or maybe that was agreed, but then it doesn't happen, and the other spouse is, just making things a bit difficult, giving excuses, and she's not feeling so well, she's going to a friend's house, so the child or the father doesn't get to see the child as per the agreement or the court order. What then happens? There seem to be a lot of divorced spouses who have issues like that.
Yeah, that's where it starts to get complicated, right? Because you have a court order and it's not complied with, then obviously it's a breach of the court order. But there is a what we call a parenting coordinator program, right?
Okay.
In which the court, if this dispute goes back to court, the court can appoint, right, a parenting coordinator, essentially a trained family law practitioner, right, or even a counselor. And the idea of the parenting coordinator is really to basically sit with the parties, right, to try and help them iron out access issues, with the idea that hopefully it doesn't escalate, right, into a full-blown litigation case, right, because it's really focused on access. And it comes back to why access is not being given. More often than not, one can sense that, it's the child that doesn't want to see. But as a family lawyer, if a client comes to me and says a child doesn't want to see dad, right? In the normal order of nature, children are happy human beings, right? They love mom and dad. Most of them, in fact, probably all of them, don't want to see mom and dad living separately. They want mom and dad to be together. So when we get into the child doesn't want to see, then a lot of questions need to be asked and answered and understood, right, from the client's perspective, from the parent's perspective. They could be very good reasons. It could be family violence issues, for example, right? It's just having to explore that with the client, with the parents, as to why. And when that happens, how sometimes it can help, the system allows that the court can order access being taking place at, for example, the DSSA, the Divorce Support Specialist Agencies, right? Generally, it starts off with an 8-session period. Over a period of time, there'll be DSSA counselors, a report was going to be prepared, it's submitted to the court with recommendations, right, as to what needs to be done next, or what kind of access orders ought to be made next, or changed or varied, right? So again, there's an involvement of a counselor who's independent, right? And I think that helps, and the children will be involved in that process. They'll see in Abigail will obviously know this better than me. There'll be a room where, it's a two-way mirror. You can see interactions, and the interactions between parent and child sometimes deals with the allegations in and of itself. A child's reaction to contact, right, with the other parent will actually tell a story by itself. And the counselors are in the best place, right, to interpret those interactions.
Yeah, in fact, it brings me to that discussion we had earlier about underlying issues. I think sometimes on the face of it, it looks like an access problem that parties, they just cannot agree or the child refuses to comply. And most times they will suspect it is the spouse that's influencing the child to not comply with all these access orders. So in your experience, Abigail, I'm sure you've encountered, whether it's children or the couple themselves, most times it must be some underlying issue. And I'm sure it will be helpful if perhaps even if the child himself or herself attends a counseling session.
Yeah, and I think just adding on to what Teong Liang was talking about parenting coordination, I think when we see couples within that context, many times they have kind of deviated from the needs of the child. So, parenting coordination, really, we seek to facilitate disagreements on parenting matters and help parents really look at how can they best co-parent together in the best interest of the child. And children, many times they get, in separation and divorce situations, you always hear the word loyalty bind, where a child feels that they are not allowed to love both parents, and something that, I always tell parents that, you're not necessarily each other's best friends now. You're always going to be the child's mom and you're always going to be the child's dad. So you don't have to be best friends, but can we just kind of collaborate and discuss and see how best we can all work together to support the child in the best interest? So what can be some shared agreements? What can be some shared narratives, so that it reduces the negative impact that the divorce actually has on the child? Yeah.
Right.
So,
and that is the journey that you take with parents as parenting coordinator, right?
Yeah. And just really looking at enhancing communication skills and how do we get them to refocus on the needs of the child. So the main focus really is the needs of the child. How do we make co-parenting work here? Yeah.
Mm.
If I may, Liyen, just to jump in on that, sorry, but Abigail's point is very, very good. It's very relevant, but just a different perspective also. I mentioned earlier about parents having maybe different parenting styles, right? It does not mean it's necessarily a bad thing.
Yeah.
It can be a positive thing for the child because the child may get, right, the best of both worlds.
Yeah.
From both parents.
Yes.
And so that's something, again, it's a question of trying to get the clients and the parents to look at it from a different perspective. And that's the perspective from the child.
Definitely. Yeah.
So there are always positives to take away. I appreciate totally, it's very hard for a spouse to look at the positives, right, when they're going through this. But that's where counseling helps, right? It helps bring them up from different levels, right, of emotions, right, and it's just moving through the different levels. And it's something to encourage. It is not always on the downside, right? There will be times there are ups and downs, certainly.
It's not all bad. So I think if we can help both individuals, both parties kind of look at what are the strengths that each individual bring in terms of parenting the child and how do we leverage on that. So that really, like what Teong Liang said, the child gets the best of both worlds, and ideally that's what we want to see.
I have heard though of people who hesitate to initiate divorce proceedings for fear of losing children, particularly if they are a foreign spouse. So this one may not just be an access question, but I'm just curious for these people, is there any assurance in the way the courts apply the welfare principle? I've encountered foreign spouses who say, my husband is the only Singaporean, and I'm not, even though maybe there's family violence, but bottom line, there's unhappiness, but I'm afraid to commence divorce proceedings because I'm afraid that I might lose custody of my child.
It's a very valid concern that obviously dovetails into transnational marriages. So the ability from an immigration perspective, right, to remain in Singapore is a valid concern. I've not come across a case where because of divorce, the ICA has terminated, right, prematurely a dependence pass or an employment pass, for example. If you're a Singapore PR, as we know, it's actually the re-entry permit that's being renewed, not the PR in itself, right? But even without the divorce, you could lose a Singapore PR for a whole variety of reasons, right? And similarly for dependents pass. But the fact that you initiate divorce doesn't mean you lose the child. Everyone can be rest assured that the courts will look at what is the welfare and interest of the child. Obviously, it is a relevant consideration if you have no family unit in Singapore, you have no family support in Singapore, those become relevant. But I don't think that in itself, right, will tilt the balance to the other parent. For example, the court looks at all relevant facts, right? Looking at the children's welfare, and it's non-exhaustive anyway. So there's no list, right? We can go to somewhere and look and say, okay, here's the A to Z, right? And every case, every family is different. I think we have to appreciate that. You just can't take something from someone who's gone through it and say that applies to my case, or take a case that's been decided by the courts before. Yeah,
that's very true. Okay, let's just quickly move on to maintenance so that we can perhaps deal with some of these topics again in the Q&A later. Maintenance, it's fairly big. In some ways, it seems separated from the whole divorce thing, simply because I understand now that the courts have made it a lot easier to apply for maintenance. And it is something that you can apply for even without commencing divorce proceedings. Would that be correct, Teong Liang?
That's absolutely correct. So you can apply for maintenance if a father generally, right, speaking husband, stops maintenance for the children or stops maintenance for the wife, right? In the course of difficulties and challenges in marriage, the law allows you to apply for maintenance on its own, for spousal maintenance or children's maintenance, without the need to file a divorce. So that can be done. But
and the procedure is quite simple?
The procedure is actually quite straightforward. It just entails going to the family court, but now with a new system, right, called IFAMS, you could do that online. Actually, you could make the application for maintenance online, and then it will be dealt with accordingly, right, in terms of the process. It's just having to have information as to what is the amount you're going to be claiming for yourself as a spouse or for the children. Eventually, you're gonna have to have the breakdown of the expenses, because that will be relevant consideration. And in terms of process, the courts will schedule, right, what they call a maintenance mediation chambers, where they will try and again assist the families, right, to try and resolve the question of maintenance. And if it cannot, then only the court will then direct for parties to put forward their evidence by way of statements or affidavits. And that's where I mentioned about the breakdown of the expenses and the supporting documents. And eventually there'll be a court hearing. So that's maintenance pre-divorce.
I see. So maintenance as part of an ancillary matter, what are the factors that the court considers in determining how much maintenance to grant?
Certainly, for spousal maintenance, we look at the income earning capacity, financial resources of the spouse. We look at age of the parties, duration of the marriage. We look at the standard of living that parties were accustomed to during the course of the marriage. So these are some of the factors the court looks into. For children's maintenance, it's about what are their basic expenses fundamentally they require, in relation to health, accommodation, education, right? Again, either way, whether it's spousal maintenance or child's maintenance, one focuses on the expenses per month. So the arguments normally will focus around, look, that's just too much, that's exaggerated, that's highly inflated. The spouse didn't have all these spa treatments, right, during the course of the marriage, and then in the last year and a half, right, suddenly because there were problems in marriage, all these spa packages started coming up, right, and massages. So trying to increase the standard of living, right, purportedly prior to the breakdown of the marriage, and then when you file the divorce, right, you claim that as a standard of living. So these are the things that we look for, and we try and assist parties, right, to reach, because it is for want of a better word, it is a numbers game, you know, and if we can narrow it down, sometimes the reality of the situation is it may not be worth going to court for that small difference. I do appreciate, as a lot of family practitioners and the courts will appreciate, that every dollar counts towards the children's maintenance or towards spousal maintenance. That is a given. But I think it's also a combination of looking at other factors in the overall context of trying to resolve it. Because maintenance for the children is never fixed. So you can have an order now or an agreement now, you know, in 5 years' time, it will be different. The kids have grown up, the expenses have changed. What exists today may not exist in 5 years' time, and new expenses come up.
Right. Yeah. And just for clarity, when it comes to child maintenance, it's not a case of maintenance stopping once they turn 21.
No. Firstly, the child's maintenance generally will be on a monthly basis, as opposed to a lump sum, because lump sum is very hard to compute, right? And it'll bankrupt a lot of people if you're trying to project 10 years down the road, right? It stops generally what we call the liability period, when the child reaches 21 years of age or becomes gainfully employed or finishes tertiary education. So the child may be over 21, but in the middle of a university degree, maintenance will still have to be provided. You know, particularly for boys, because they have a 2-year NS commitment, right? So by the time they start university, they are probably already 20 plus, going into 21.
Okay, so what action can a parent take if payment of child maintenance is stopped?
So this assumes that there's a court order for maintenance, then if it stops and no payment is made under the court order, then you can go back to the family courts to enforce it. The process is quite simple and straightforward. Yeah, you know, the courts have looked at it and improved on the systems over many years. And it's quite simplified now. It again, through IFAMs, right, on the portal, you can actually apply for maintenance. What you probably need, or what you will need, is the copy of the court order, and you need to identify when payment of the maintenance stopped and what is the amount of the arrears, most importantly, i.e. what has not been paid, and proof of that non-payment. So a lot of the maintenance orders now, it's payment into the spouse's bank account, not the children's bank account, because they obviously can't manage it. So the proof of payment on a certain date is quite easily identified because it's payment into a bank account. So there's less dispute there. So don't make these payments by way of cash over the dining table or something, or leave it in an envelope, because it just leads to a lot of disputes.
I see. Okay, so it's better that there is a record somewhere, banking statement.
That's correct. And the court orders will always say that the payment of the monthly maintenance will be paid into a designated bank account.
Okay.
Yeah.
Okay. Now, this one is interesting. Here's a question, right? My husband threatened me, saying that if I go to court to apply for maintenance of our child, he will prove to the judge that he has no money and can't afford to pay anything. But every night he has money to go out drinking with his friends. And this wife thinks that it's because his father gives him cash to spend, which means that he is perhaps on the face of it able to show the court that he's not working, has no money. So in circumstances like that, are the court's hands tied, because it doesn't show that he can afford to maintain his child, but this person clearly has some means?
Yeah, I don't think the hands courts are tied. I think the obligation then rests on the husband in that case, right? To prove that he has no money. He would then have to explain how he maintains himself on his own monthly expenses. If he has no job, my experience, I don't think, unless there are medical reasons or very good reasons why you can't work, you're unlikely to get a pat on your back, right, for not working, so that you can't maintain your kids. You'll probably be expected to find some form of employment, right, or at the very least to make efforts, right, to find employment. So there are many hurdles, I think, a party of that nature who wants to contend that he's got no money simply to make payment of maintenance for the children. And again, because the welfare of the children, right, is paramount. You know, their school books, their meals, their tuition, their school activities all have to be financed and paid for.
Yeah. Okay. Let's move on to division of matrimonial assets then. before we, and a few more slides before we come to the question and answer session. Maybe very quickly, what is the court's approach when it comes to division of matrimonial assets? I do know of people who are concerned that some people will think that it is a 50-50 division. Some people will think that they will get nothing out of the divorce. So that also leads to a concern with commencing divorce proceedings. Perhaps they feel that their spouse is able to siphon off or put aside some assets that then they will not be able to prove to the court, and then that will affect the division of matrimonial assets. So I think there are some common concerns like these. But to start, perhaps, what is the court's approach when it comes to division of matrimonial assets?
The approach is, under the law, what is called a just and equitable division. I'm sure that doesn't help anybody out there, right? Like, what's the meaning of just and equitable, right? For one, it doesn't mean a 50-50 split. It's not automatic. Secondly, the courts look at what parties have contributed towards the acquisition of these marital assets. And the contribution comes in two forms. One is what we call the direct contribution. Simply put, who paid what towards the down payment, who's been paying the mortgage through CPF or cash, for example. Renovations are also considered direct financial contributions towards the acquisition of a home, for example. What a spouse has in terms of his investments, cars, bank accounts, these are also considered assets during the marriage. And that's also part and parcel of direct financial contributions made by a spouse towards the pool of the assets. So the starting point is really to try and identify the pool of assets and then look at how to divide that pool of assets. So the second aspect is what we call the indirect contributions. And there are two components to this. One is the non-financial contributions, more commonly understood as the role of the parent, right? The role of wife, mother, role of husband, father, right, towards the marriage. The second sub-element of indirect contributions will be the indirect financial contributions, which means who's been paying all the household expenses, the family's expenses during the course of the marriage. Right? And this really applies in cases of dual income, families, and the courts adopt this approach, right, of looking at direct and indirect. But notwithstanding that, if you have a single income, the courts do also look, right, at contributions, right, because to give an example, in the short marriages with no children, right, the courts are likely to look at the financial contributions because the indirect contributions take on a lesser significance. But you have a long marriage, and generally speaking, long marriages are marriages of over 20 years with children, right? It's a very hard place to go and start looking for documents who paid what, 15, 20 years ago, right? So the inclination of the courts, is to look at equal division because the partnership, right, in a long marriage with children are more likely to be equal. In terms of contributions, and some, depending on the financial arrangements of the family also. You may have a husband paying for financials, but the wife equally contributing just as much, right? And recognition is given under the law for the non-financial contributions. So right. that is how the courts in general, as an overview, right, look at division of assets. On the point of hiding assets, it's a valid point. Sometimes it's a concern of the parties. It becomes again complicated because then we have to go and track and do tracing, right? And I think the starting point probably is bank accounts. We see sudden movements, large amounts going out, shortly or around the same time as the problems in the marriage arose. Those are indicators, and the party has the right to ask and explore questions, right, as to what was the purpose of the withdrawal, where they went to, etc. So it becomes more tedious, no doubt. It becomes a lot more work to be done, right, in trying to track where the assets went.
And what happens when, okay, so you trace and say, the money has already been spent a I don't know, acquiring some asset. So what you mean by that is then that new asset also forms part of the matrimonial, the pool of assets.
That's correct, because it's acquired during the marriage. If the money is spent, for example, on family's expenses and it can be shown, then it's not a pullback of that because it's expended for legitimate purposes. Sometimes we hear that, oh, very simple, right? I just say I've taken the money and I lost it all at the casino, right? Judges are not impressed with that, I can say for sure, right? If you spend it for your self-gratification, right? That's not a rationale for not dividing it or maintaining the kids through maintenance for that. So there is an ability, if the evidence would show that there's been a dissipation of assets or hiding of assets and non-disclosure of assets, there is this terminology as a matter of law called adverse inference that can be drawn, right, by the court in making a finding that perhaps the spouse is a lot wealthier than he says he is, or that he puts himself out to be. Right? Obviously, how the courts draw the adverse inference in quantum is also a different set of questions, right? And the law takes on differently whether you can identify it or you can't identify the amount that's been withdrawn. If you can identify it, simply put, it goes back into the pot notionally. Right? If you can't identify it, the court cannot just ascribe a value, but they look at then dividing, maybe adjusting the percentage, right, a bit higher on what has been disclosed as the assets to be divided.
So I'm curious, right, Teong Liang, because earlier we were talking about over 60% of applications are on the simplified track. That means parties have agreed to all these things already. But now when we discuss the issues one by one, sometimes it really seems quite complex and complicated. So in say a mediation setting, how can the mediator and how do parties come to agree on something like division of matrimonial assets?
Very good question. So mediation, whether it's done private sphere or in the courts, right? What normally happens as part of that process is parties will exchange proposals for a settlement. Parties will normally be directed, or will be directed if it's a court mediation, to disclose and exchange documentation, what we call financial documentation. So that would normally entail income documents, income tax notices of assessment, generally for last 3 years, bank statements, last 3 to 6 months, information on the direct contributions, CPF statements, things like that. So those documents will be exchanged as a matter of course, right? And in my experience as private mediator, we do adopt that approach also. And simply because then both parties know, right, what each or the other has in that sense. Particularly so if there's a spouse, commonly speaking, maybe the wife, right, who's not in the picture because she's a homemaker, may not know where the assets are, etc. So that becomes even more important. Or in some cases, vice versa, right, when it's actually the wife that earns a lot more and knows where the assets are, and the husband actually doesn't know.
Yeah. It's assuring good to know that, even in a mediation scenario, this can be resolved. Yeah.
Indeed, it can, yes.
Okay. So before we do Q&A, I would like to discuss some of the latest developments in the family courts. In particular, I know the family courts intend to introduce therapeutic justice as the approach to all divorce cases going forward. So this is a new term to all of us, I'm sure for all participants as well. So I understand it to mean that going forward, the family courts will adopt a more problem-solving attitude to all matters brought before it, and it will strive to not encourage the adversarial system, which I think to some extent is still practiced currently. So for an individual or parties trying to get a divorce in Singapore, how will therapeutic justice benefit them? And what is it anyway?
I think therapeutic justice, you're right, it moves into looking at problem solving, taking positions that doesn't, and a judge making a court order doesn't necessarily solve the problem for the parties and the children. So what we have been discussing and how we look at things from different perspectives, for example, right, in what Abigail has discussed and what I mentioned in some examples, is really part and parcel of therapeutic justice. It's about getting the clients to look at things, right, from a different mindset, different perspective, and what terminology therapeutic justice also entails is with a lens of care, right? So how this is done is family lawyers play a role, an important and critical role in this approach, because family lawyers, if a client comes to us and we encourage litigation, for example, right, it takes a different trajectory. But if we sit with the client and no, this is not going to happen realistically over one meeting, right? It takes several meetings. Abigail would know better, right? Because counseling doesn't happen overnight, right? It then shifts the thought process, the mindset, and the approach, right? So it's about the approach to the resolution of the dispute between the parties. And the courts have also, as part of this, are piloting what is called a multidisciplinary approach, right? Or a multidisciplinary team, which involves non-lawyers, involves the mental health professionals. I think recently you would have read that the courts have also signed an MOU with financial consultants to assist the parties in those aspects also. So it's about, in the very high conflict cases, before a court even gets to making a decision, more likely than not the case, if appropriate, the courts will adopt, right, the MDT approach, right, to try and see if we can resolve the high conflict issues. So that's all part and parcel of the therapeutic justice. It's also about communication, which I alluded to, how we speak even to parties, how parties speak to each other, things like that.
Right.
It's a whole host of moving parts, right, actually. And
what do you think, Abigail? I mean, sorry to interrupt, please.
I really like it. And I think also with the cases that I've seen, I think there's been a very nice shift. Previously, no offense to any of the lawyers, but I do hear a lot of clients complaining, oh, all these lawyers' letters, and then I get sent this, and then it's very intimidating, it's very fear-inducing. Now it's very nice to hear that shift about the additional support and care that is coming to clients. And then, I hear things like, I'm going for a mediation session, talking to court counselors as well. So it really does, I feel, help to reduce the intensity of the acrimony. And I mean, I'm biased, but then, I'm always thinking about those with kids. It really, really helps the emotional and mental state of the kid. And so that, parents, hopefully when this aspect is reduced, they are not carrying some of these residues back into the home environment where it could potentially be absorbed negatively by the kids and loved ones who are involved in this. So I really like the holistic perspective and the direction that this is heading.
Okay. Teong Liang, this multidisciplinary team that you were talking about, we're not talking about a tribunal who hears a case, right? How does it pan out? How does it work in practice?
Counselors may be appointed to assist the parties and the children to work through high conflict issues involving the children. So it's not about a tribunal, it's still a judge that oversees the case. But the mental health professionals or financial professionals will be involved in that whole process, right? To work with the parties and their lawyers, really, to try and find a solution around the problem and around the challenges. So it's not adding people on to make decisions. It is really getting expertise, right? From social science, for example, right? To educate parties, parents, and even help the children through the process to find the right solutions at the end of the day.
Right. And assuming this works well, therapeutic justice, I suppose that the long-term aim is for parties to go on the simplified track more. And only because they have, with all this additional help, been able to come to agreed terms for the way they want to move forward, I suppose.
A slight distinction there, if I may, because once you talk about the multidisciplinary and the courts, getting people involved, the case has already gone to court. So the simplified track is unlikely to
that's true.
Deal with it, because the simplified means you don't need a multidisciplinary thankfully, right?
Yes.
Yes, yeah. So just that distinction, just to highlight.
Yeah, I stand corrected. But the aim is basically for parties to themselves be able to decide on these matters. And so the final order would be, ideally, would it be, I mean, are we trying to get individuals to agree?
The answer is yes. If you could, in this entire process, right, get parties to agree, the answer would be yes. It would be great,
Okay.
right? Because I think the research has also shown that if parties become stakeholders to the outcome, right, it lasts longer. There's lesser variations in the future, and they're likely to withstand the test of time.
Yeah.
You know, and it's an important platform where they can stand on to move things forward also.
Right. Yeah. Okay. So let me then just move on to the Q&A session. We've got some questions from participants, and maybe I will start with this one regarding division of matrimonial assets. This participant says, if my husband owns a private property before marriage, after marriage, I help to pay the upkeep of the household bills as well as the renovation. Will this property be considered as part of the pool for division if I don't have ownership of it?
The short answer is yes. Without putting my lawyer's head, there'll be a lot of questions I have to ask, right? But just moving that aside, ownership is not the determining factor. It doesn't mean that if you're not a legal owner, you have no share. Okay. In this question, it's a premarital asset, but during the period of marriage, I hear part of it is you paid for the renovations. So it could be substantively, or what they call as a matter of law, substantial improvement, right, made to the value of the property because of the renovations. If you can show substantial improvement, then the property goes into the pot as a matrimonial asset. It could be also a premarital private property, but if it's used as the matrimonial home during the marriage, it goes into the pot automatically also, right, for division. But if it's not a substantial improvement, or let's say you paid for the mortgage during the period of the marriage, right, that also can be considered. But just to close the loop on this, so if the husband owns a premarital asset, private property, and then during the marriage, he's been paying the mortgage, right, for the 10 years in the marriage, right, that property is considered as a matter of law transformed, right, into a matrimonial asset. What will generally happen is they may take the difference of the values pre-marriage, right, or the time of marriage and the time of the divorce, because some of the acquisition in that sense is not complete, right? So part of the acquisition up to the time of the date of the marriage would not have any, should be taken out in terms of the value, and you take the difference in value.
Okay. This is an interesting question about care and control. A bit sad. Are there cases where both parties do not want to claim custody of the children? And if yes, is the court going to force one of the parties to take custody of the children?
Okay. I have come across, thankfully not often, but it won't, that kind of scenario probably, in my view, would not reach a judge to decide. I think in the course of the CFRC, in the course of mediation, I think the counsels would probably be involved quite a bit in terms of trying to explore why each parent don't want the child, and the rationale for that. So I think that part will probably take a long process if they are really looking into taking that view, as opposed to a court forcing one parent to take it. So I think that approach may be different, and if it's really that kind of case, then I think the counsellors will play a huge role, right, an important role.
Right.
Speaking to the parents, yeah.
Okay, one last question on custody. If my children don't agree with the custody arrangements, what will happen?
It's a tough question, not unusual. This is about children deciding, right? So, generally, children ought not to be placed in a position, right, or in a place where they have to choose, right, what they want and what they do not want. A lot depends on the age of the child, maturity level. The law says that the wishes of the children are taken into account, but I would just caution, wishes actually doesn't mean you go and tell your lawyer, my child said this, my child said that, right? Because we don't know whether there's been a huge amount of influence. We don't know, before the child actually says it, what's happened in the background. So a lot of this is sussed out, right? Whether it's an independent view of the child, because that's what's required as a matter of law. It's really sussed out with the expertise of the counselors like Abigail, right? Who can tell a mile away, right? Whether this is the mom or dad speaking, or the child parroting the mom and dad, mom or dad, that kind of stuff. Or is it really a view? And it comes in many different ways, which Abigail will be able to explain.
Interesting. Okay, so let's close on a slightly more positive note, right? After final judgment, these participants asked, where can I seek counseling for co-parenting?
Again, I think when we allude to like counseling and all that, really the options that I mentioned just now, family service centers, private counseling. So at any point, even before final judgment, after final judgment is being given, inquiries can be made for counseling. Yeah.
Okay. So any closing remarks before we close today's webinar from Abigail? I mean, just a reminder to participants. Yeah.
I usually have this phrase that it might be really difficult and it might be a lot of hard work. It's usually worth it at the end. So do all the best that you can to try to make things work. Yeah.
And I would personally say seek a counselor for help, especially if you know that your emotional state, I think it affects decision making on every level. Would you agree with that, Teong Liang? I mean, we started this whole thing talking about the emotional state, and the divorce journey can be a long one, even if you're doing mediation or going the usual way through the court process. I think having at least seen a counselor to better understand what is the journey going to be like and how you can better take care of yourself during the process would probably even help with decision making.
Indeed, I agree. I think if I could add on to that, sometimes if you go and see a counselor, I mentioned the word awareness earlier, right? Children have different stages of development. Counselors will have seen the impact of divorce or marital disputes between the parents on the children. Sometimes it doesn't surface now, it surfaces many years later, sometimes even in adulthood, right? But I think bringing that awareness to parents, right, is something that's critical and important, right? Because, in the heat of the dispute, right, these things get lost somewhere in between and it's very hard to find. But I think the counselors will help parents focus on that. And I think that's important, yes.
Yeah. Okay, thank you both very, very much. So we have to bring this session to a close. Thank you all for joining us. Please remember to download the useful resources regarding the issues we've discussed today. We hope you found today's webinar on divorce useful. Your feedback will help us to make future webinars more relevant and useful to you. So when you leave, you will receive a survey on your browser, and we very much appreciate your feedback on today's session. Teong Liang and Abigail, that was so insightful, and thank you very much for spending your evening with us. And on behalf of Law Society Pro Bono Services, thank you for joining us today. Have a great evening and stay safe.